All right, today we're going to talk about something that affects pretty much anyone with a job, your work computer. We're diving into a landmark Canadian court case that all started with a hidden folder and ended up totally redefining the line between your private life and your work life.
I mean, it's a huge question, right? And the answer, well, it's not a simple yes or no. To really get why, we need to dig into the real-life story of a high school teacher. His name was Richard Cole, and what was on his work laptop sparked a legal fight that went all the way to the Supreme Court of Canada.
So this whole thing kicks off, not in some fancy courtroom, but in a totally normal high school. The main player here, a standard issue work laptop, the kind they give to a teacher. And just like so many of us do, he used it for everything. Work stuff, personal stuff, all jumbled together. And get this, the school's own policy actually said that was okay.
Okay, so here's how it all went down. A school tech is just doing some routine maintenance on the laptop, and whoops, finds a hidden folder. Inside, he discovers explicit photos of a student. So, he tells the principal. The principal then seizes the laptop and gets the technicians to copy all the files. And then, and this is the part where things get really serious, they hand the laptop and the copied files over to the police. The police then search everything without getting a warrant, and that is the exact moment this whole thing explodes from a workplace issue into a massive constitutional battle.
So you can see how this all spiraled, right? These actions, which might seem kind of logical at first, created this huge legal mess. It all boils down to one central question for all of us. If your boss owns the device, where does their right to their property stop and your right to privacy begin?
And this really gets to the heart of the fight. On one side, you've got the employer, the school board, saying, hey, it's our property, it's our laptop, we have every right to search it. Makes sense, right? But on the other side, you have the employee, Richard Cole, arguing, hold on, yeah, it's your laptop, but it contains my life, my private thoughts, my messages, everything. The court would later give this a fancy name, the biographical core. So the real question becomes, does owning the box give you ownership of all the secrets inside?
So the Supreme Court had to step in and weigh these two really powerful arguments. They needed to come up with an answer that would set the rules for basically every workplace in the country. And their decision? Well, it was not simple at all. It was actually pretty brilliant. Check this out. This is the key line from the court. What they said was, yes, you absolutely have a reasonable expectation of privacy on a work computer. But, and this is the big but, that expectation is diminished. Think of it like this. Your privacy isn't a big, solid wall. Because it's a work device and there are workplace policies, that wall has a few windows in it. It's smaller, it's diminished, but it's not gone. It hasn't been completely knocked down.
And this is why that diminished right still matters so much. The court basically recognized that our computers, work, home, whatever, are not just tools anymore. They hold what they called our biographical core. I mean, think about it. Your computer knows your browsing history, your private messages, your weird late-night searches. It holds the story of your life. And because it holds that deeply personal stuff, it gets constitutional protection from the government, even if you don't technically own the laptop itself.
All right, so let's recap. The court says Cole had a right to privacy. The police searched his laptop without a warrant. Therefore, the police violated his rights. The search was illegal. Simple, right? Well, not so fast. That just opens up a whole new can of worms. Now the question is, what do you do with the evidence they found during that illegal search? Do you just throw it all out? And this is where things get really fascinating, because even the top judges in the country couldn't agree. See, in Canada, just because the cops break the rules to get evidence, it doesn't mean that evidence automatically gets tossed. Instead, the court has to do this balancing act. They have to weigh three big things to decide if using the evidence would make the whole justice system look bad.
So let's break down that disagreement. It all came down to how the judges saw three key things. First, how bad was the police conduct? The majority said, it wasn't so bad. It was an honest mistake. The law was fuzzy here. But the dissent was like, no way. This cop was a cybercrime expert. He should have known better. Second, how much did the search impact Cole's rights? The majority figured his privacy was already diminished, so the impact wasn't that severe. The dissent, again, totally disagreed, calling it a massive invasion of his entire digital life. And third, what about society's interest? The majority focused on getting to the truth of a serious crime. The dissent argued that protecting everyone's rights from illegal searches was more important here.
So, at the end of the day, the majority opinion won. They decided that even though the search was illegal, using the evidence wouldn't make the justice system look bad. The verdict, the evidence was allowed in. The case was sent back for a new trial, and this time, the prosecution could use everything they found on that laptop. Okay, so this case is from 2012. You might be wondering, why are we still talking about it? Because everything this case decided is basically the rulebook for your digital privacy at work right now. In our world of remote work, company phones in our pockets, this case is more important than ever.
So, let's just nail down the key takeaways from this whole thing. First, you do have a reasonable expectation of privacy on work devices. Period. Second, that expectation is diminished, it's not absolute. Your company's policies really do matter. Third, and this one is so important, your boss's right to look at their property does not transfer to the police. Your employer cannot give the cops permission to search your stuff. And finally, that means the police almost always need to get a warrant to search your digital info, even if it's on a work device.
Look, the ideas from this case are more critical today than they've ever been. The line between work and home is pretty much evaporated, right? It's all happening on the same device, maybe the one you're even watching this on. And that forces us to constantly re-ask the question that this case brought to light. When your office is literally in your pocket, what does privacy even mean anymore?